Hi, this is Judge Herb Dodell. Last week we talked about mediation, which is a voluntary process where you use a third person to help you get cases resolved, taking the ego out, convincing you how bad your case is and how good theirs is, and vice versa. Today we're going to talk about a different process called arbitration. Arbitration is like a trial. It's usually held in front of one person, although there are arbitrations where there are three arbitrators. Each side picks an arbitrator, and the two arbitrators pick the third, which is called the neutral. I prefer the one arbitrator, even though it's a lot more risky. If you got the arbitrator on your side, it's great. That's all you have to do is convince the one person. But when you have three, you have somebody actually standing in as an advocate for your side, but the other side has somebody as well. Now, this is different than mediation because in mediation you pay for someone to just serve as a voluntary neutral person to try to get your case settled. No binding effect. If it doesn't settle, it doesn't settle. Arbitration is different. In fact, many contracts, in fact, there was a case last week from the United States Supreme Court, a 5-4 decision saying that parties can be forced to agree to an arbitration provision in their contracts. And a lot of the companies are doing that now. Why is that? Because you avoid the runaway verdict that you can get from a jury. An arbitrator is generally going to be somebody who knows the subject matter and is going to be able to make rulings, evidentiary rulings along the way. Again, the same as with a mediator. Find somebody who knows the subject. If you're dealing with insurance issues, find an arbitrator that knows insurance issues. If you're dealing with personal injury, find somebody who knows all about personal injury. That's the way you do it. Now, the problem with arbitration, at least in my experience, is that there's really no appeal. If the arbitrator makes a mistake of law, it doesn't make any difference. Arbitrator makes a mistake of fact, makes no difference. And that's a problem because the arbitrator can make discretionary calls that you think are ridiculous, and there's nothing you can do about it. It's pretty much, for the most part, a done deal when you finish with the arbitration. If you can't agree on an arbitrator, usually the court will do that for you. You make a motion, it's called a motion, to the court to compel arbitration, and the court will pick somebody. The problem is they usually pick somebody that they like, one of their own friends, because you have very little control over who's going to decide your case. So the bottom line, arbitration and mediation are different. One's voluntary, one is basically mandatory. If you want to know more about arbitrations and mediations, and I've done many, many over the years, feel free, contact me. It's called AskJudgeHerb@gmail.com, or watch the show, or even read the book. The book is called From the Trench to the Bench, Navigating the Legal System and Finding Your Spiritual Path Along the Way. See you next time.